Hello and welcome to Courts Today by Live Law. Let us start with today's major headlines. The Rajasthan High Court has issued notice on a suit claiming a Shiv temple lies beneath the Ajmer Sharif Dargah. In the Delhi air pollution matter, reports have indicated abject failure in implementation of GRAP-IV measures. The Supreme Court has now sought response of the NCR states. The Supreme Court has asked the Animal Welfare Board to get approval for rules on birth control of feral and free-ranging dogs in wildlife areas. The Supreme Court has refused to cancel the bail of a man booked over alleged links with ISIS. The Apex Court has criticized the Himachal Pradesh government for opposing appointment of Asian Games medalist. CBI has filed an application in the Supreme Court to transfer trial against Yasin Malik from Jammu to the court in Tihar jail. And the Madras High Court has held that magic mushroom per se is not a narcotic drug. Quantity of psilocybin present must be determined to check the commercial quantity. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Let us now dive into the details. A new case has come up in Rajasthan now with the claim that Ajmer Sharif Dargah was built over the remains of a Shiv temple. A case in this regard has been filed by Hindu Sena President Vishnu Gupta, and Civil Judge Manmohan Chandel from the Ajmer District Court has issued notice to the Archaeological Survey of India, Union Ministry of Minority Affairs and the Ajmer Dargah Committee. The suit seeks directions to the ASI to conduct a survey of the Dargah, the mausoleum of Sufi Saint Khwaja Moinuddin Chishti, and to reconstruct Bhagwan Shri Sankat Mochan Mahadev temple at the site after removal of the present structure. It is claimed that the Dargah appears to have been built on the sites of old Hindu temples, partly by converting and partly by adding to the structures already existing, as was usual in the times of early Muslim rulers. It has further been submitted that the plaintiff has a direct interest in protecting and preserving the religious character of Mahadev temple at Ajmer at the site of Khwaja Dargah Sahib from illegal and unauthorized occupation by the Dargah Committee. The matter has been posted for further hearing on 20th December. Stay tuned with us. As you know that the Supreme Court is continuously monitoring the Delhi air pollution matter, the same was today heard by a bench of Justice Abhay S. Oak and Justice Augustine George Massey. The reports submitted by the court commissioners suggested an abject failure on the part of the authorities in implementing the GRAP-IV measures to address the severe problem of air pollution in Delhi NCR. This is because construction activities are ongoing in posh colonies, factories are running 24 hours, and waste burning is still happening. Regarding the ban on truck entries, amicus curiae senior advocate Aparajita Singh submitted that trucks should be stopped at the NCR border instead of the Delhi border. She also cited the report of another court commissioner which stated that cement was being transported in some trucks under bags of wheat flour because wheat is an essential commodity and is exempted from the restrictions. The court has said that GRAP-IV restrictions will continue till Monday and further course of action will be decided by the Commission for Air Quality Management. The court called for a response from the NCR states by Monday on the measures they propose to take against the breaches that are happening. Also, the court criticized the Commission for issuing a clarification today allowing certain construction activities in Delhi NCR. The court has asked the Commission to withdraw the notification. In the next update, the Supreme Court has today directed the Union of India to get approval from the concerned ministry regarding rules of birth control of feral, free-ranging and domestic dogs that attack or hunt wildlife in protected areas and forests. In this case, the petitioner prayed for directions for the management of such dogs and wildlife, including their identification. It was the case of the petitioner before the court that although the Animal Welfare Board of India has framed guidelines regarding stray dogs, there are no guidelines pertaining to free-ranging dogs. They have become a danger to many countries and species such as the Great Indian Bustard. The council representing the Animal Welfare Board of India today said that as per the last order of the court, the matter was sent to the Animal Welfare Board of India, which has now arrived at a common solution which is accepted by the petitioner and the Union of India. She added that the said proposal pertains to the birth control of dogs and needs to be approved by the concerned Ministry of the Government of India. She further informed the court that the rules are already in existence and that the dogs in question are only found in 3 to 4 states near forest areas. A bench of Justices Sudhanshu Dholia and Ehsanuddin Amanullah has asked for the permission to be taken quickly on the proposal. Last year in December, the Madras High Court had granted bail to a man named Asif booked under Unlawful Activities Prevention Act for having links with the terrorist organization ISIS. The allegation against Asif was that he was a staunch supporter of Islam rule in India and the terrorist Osama bin Laden and had been following the ideology of Al-Qaeda. He was said to be in close contact with a co-accused who was a member of ISIS and had even intended to murder the members of Hindu organizations. But Asif contended before the court that he had been in custody since July 2022 and that the nature of the allegations were not such that required a prolonged pre-trial detention. It was also submitted that the authorities had not recovered any incriminating evidence against him except a mobile phone. The High Court had granted him bail for prolonged incarceration and by observing that whether killing of Hindu religious leaders would itself constitute a terrorist act was debatable. The matter reached the Supreme Court and was heard by the bench of Justices Suryakant and Ujjal Bhuyan. The bench today denied to interfere with the order or cancel the bail granted to Asif. But the court was not happy with some of the comments in the order of the High Court. So it has expunged the High Court's remarks on text message evidence, applicability of UAPA Section 38 Clause 2, and sanction issues, stating that they were irrelevant to the bail decision and cannot be treated as a precedent. Notable sportspersons are often awarded prestigious government jobs as a mark of respect for their contributions to the country. These positions provide financial stability and encourage a sense of duty towards the nation. Those excelling in national and international sports are often offered posts in civil services under special sports quotas. For example, boxer Vijender Singh was appointed as a DSP in Haryana. In a similar case, the Supreme Court was today dealing with the case of Kabaddi player Pooja Thakur from the state of Himachal Pradesh. She won a gold medal in the Asian Games of 2014. Since 2015, she has been requesting the government for her appointment to the post of Excise and Taxation Officer. As per a single judge order, the appointment was to be effective from the date of her application to the Chief Minister in July 2015. The High Court also upheld this order in 2023, and today a bench of Justices Abhay S. Oak and Augustine George Massey of the Supreme Court also denied to interfere with it. The court criticized the Himachal Pradesh government for denying appointment to an Asian gold medalist in the sports quota. The court said that the Chief Minister should have adopted a pragmatic approach. The CBI has filed an application in the Supreme Court seeking transfer of Kashmiri separatist Yasin Malik's trial from Jammu to a court facility within Tihar jail where he is currently lodged. This is in reference to an order passed by the Jammu trial court to physically produce Yasin Malik in the case related to the killing of 4 Indian Air Force personnel in the year 1989. The CBI has raised security concerns in transporting Malik to Jammu. According to them, this could also be a threat to the witnesses, keeping in mind that one of the witnesses has already been assassinated. The CBI wants the trial to be in Delhi so that Malik can attend it from Tihar jail, as the place has video conference facility and past proceedings have also taken place there. With the transfer petition, another application was filed to add some co-accused as parties in the appeal, expressing that all accused and not just Yasin Malik must be heard before the trial is transferred. The court has issued notice and the matter will now be taken up on 18th December. Magic mushrooms, known for their psychedelic effects, are sparkling legal debates. Some nations recognize their therapeutic benefits while others ban them outright. The Madras High Court has held that magic mushroom per se does not satisfy the requirement of a narcotic drug or a psychotropic substance under the NDPS Act. The court was hearing a bail petition filed by a man named Mohan who was arrested after being found in possession of 60 grams of magic mushroom kept in his pant pocket. After this, a case was registered against him. Mohan argued that magic mushroom was a natural product available in deep forest and had not been cited under the category of narcotic drug or psychotropic substance. He submitted that what was recovered was magic mushroom and not psilocybin, and hence the mushroom itself could not be treated on par with psilocybin. Pointing out the FSL report had not mentioned the quantity recovered, he argued that assuming 60 grams of magic mushroom was equal to 60 grams of psilocybin was not correct. The court actually agreed with his contentions. Thus, considering that there were no previous cases against him and that Mohan had been in jail since August this year, and because the trial would take time to commence, the court has granted him bail. Justice Anand Venkatesh held that magic mushroom was not per se a contraband and can be considered a contraband only when it contains psilocybin. I must tell you here that this reasoning is different from which was taken by another judge of the same High Court, Justice Bharat Chakrabarti, who held that prima facie every cell of magic mushroom contains chemical and should be weighed entirely to determine the commercial quantity. Thank you for watching. For more information on the cases discussed here, you can visit our website at www.livelaw.in. Your support means the world to us. So do not forget to like, share and subscribe to our channel. You can also support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month. See you tomorrow.